Derek Gonzalez.
Present, appearing by affidavit.
Okay, sir, I've received your affidavit. If you'll please come forward and have a seat at the table.
I can't pass the bar. I've appeared by affidavit. All the questions have been asked and answered, and I just need another date to appear as far as my knowledge, as far as to my understanding of it.
Well, Mr. Gonzalez, you are Derek Gonzalez, correct?
Derek Gonzalez appeared by affidavit.
Mr. Gonzalez,
Sworn
you're charged
affidavit.
with 3 counts. Count one is no valid registration. It's a class 3 misdemeanor, carries a maximum 3 months imprisonment, $500 fine, or both, no minimum. Count 2 is a charge of no proof of insurance. That's a class 2 misdemeanor, carries a maximum 6 months imprisonment, $1,000 fine, or both, no minimum. In addition, sir, if you're convicted of that offense, you would be required to provide an SR-22 to the Department of Motor Vehicles for a period of 3 years, or your operator's license would be suspended. Count 3 is no license on person. That's a class 3 misdemeanor, carries a maximum 3 months imprisonment, a $500 fine, or both. You understand the 3 pending charges and the possible penalties, sir?
I'll need you to put that in writing and
Sir, did you receive a copy of your complaint?
send it to the.
Sir, did you receive a copy of your complaint? That's a yes or no question. Did you receive a copy of your complaint?
I don't believe I have one. Do you have one on file? May I
Mr.
appear?
McQuaid, do you have an extra copy of the complaint you can hand to Mr. Gonzalez?
Please, for your honor, just a second.
So is the complaint, is that the original bill charge
Your Honor,
ticket that was
uniform citation and complaint
that was drawn?
Have a long form.
And I see that there's a lack of wet ink signature on that, and also there's a discrepancy with that wherein the signature is not recognized by the defendant as it appears that it has been altered. This is all in my affidavit, so I'll give you guys time to read that affidavit and review it.
I'm not going to read your affidavit. What we're here
that's
for
fine.
today, we're here for first appearance, called an arraignment. I advise you of the pending charges, I advise you of your rights, and I advise you of the possible penalties.
Yes, and Derek
then,
appeared by
sir,
special
I ask you
affidavit.
if you wish to have time to talk to an attorney, and if you want time to talk to an attorney, I'll grant you time. And if you can't afford an attorney, I will appoint an attorney to represent you. Sir, and then at some point, if you wish to enter pleas with or without an attorney, I'll take your pleas, and you can enter one of the 3 pleas, and then I'll set the matter for trial, and then we'll take up your evidentiary issues that you wish to assert.
Point of
But the way
clarification.
the process works, sir, is we go through the first appearance and arraignment, then we take a plea, then we set the evidentiary hearings. We're not going to argue evidence today. We're going to arraign you today. So there are simple questions. Do you
Objection, I got a
understand
point of
the pending
clarification,
charge?
please. In the Constitution, it's very clear that I have a right to a jury trial. It doesn't say multiple trials putting me in jeopardy time and time
Sir, you do have a
again.
right to a jury trial. And you also have a right to have that trial set. But we can't set a trial until we have you enter your plea and you go through the arraignment process. The case law is very clear on that.
So has a grand jury federally indicted me at this point? I'm curious because that's one of the criteria in order to
There's
be.
no requirement for an indictment.
So this is a
State law
special-
simply provides that a complaint be filed against you and that you appear to answer that complaint.
So is this a special proceeding in a special court then, sir?
This is the state court, sir. It's a county court.
Wonderful.
It's authorized by the Constitution of the United States and the Constitution of the state of Nebraska.
And is Derek Gonzalez, is he entitled to a fair and meaningful hearing?
You are entitled to a trial, sir, but until you go through the arraignment process and enter your plea, we're not taking up your evidentiary issues.
Okay, and if there be a conflict of interest, how would that
We'll take that
work?
up after your arraignment, sir.
After the arraignment, but it wouldn't happen before, and the reason for that
It would
is
happen before the trial, after the arraignment. That's how the process works.
because I believe Derek sees a clear conflict of interest and has articulated that in the sworn affidavit before the court today, whereas the alleged judge, ministerial administrator, is a bar member. The prosecuting attorney is also a bar member. They both work for the state entity. They both get paid by the state,
Well,
and
where
that's a
you're
clear
wrong, sir.
conflict of
That's
interest.
where you're wrong, sir. See, you should do some more research.
So you don't
Mr.
work-
McQuaid does not work for the state of Nebraska.
He works for the county. I understand that. He's also paid out of the state treasury.
No, he's not.
Yes, sir. I
No,
can
he's
prove
not.
that logistically. Okay, so what I need.
So where's your, you got a copy of Mr.
Well, today you
McQuaid's
said-
payroll stuff? Because I'm
Today
sorry,
you said that evidence
I-
cannot be put on the record, so we'll wait for a later date on that. So my next question is, I need everybody's oath of office and bonds. Their bonds should be on the face of the instrument of their oath. And those are some of the things that I'm going to require in order to do business with you
Well,
guys.
Mr. Gonzalez,
Because you're private.
I don't know who you think you are. I'm not going to treat you any differently
I'm just
than
a
any
man,
other
sir.
individual. But Mr. Gonzalez, we're here today for arraignment. Today I'm gonna find that you, I'm gonna ask you one more time, do you understand the three pending charges in the possible penalty?
I do not comprehend, I need clarification
Would
yet.
you like me to order a competency evaluation? Have you committed to the regional center, sir?
If a quid pro quo is in order, are you also going to be participating in a mental evaluation as well?
No, sir, I don't think I need one. Because
I don't think I need one either, so we're in agreement with that.
So I'm going to find that you do understand your complaint. I'm going to find that you understand the possible penalties.
That is incorrect.
Mr.
Objection.
Gonzalez,
I object to that. You're violating my substantial rights at this point.
Mr. Gonzalez, do not interrupt me while I'm talking, please. You've been advised of your constitutional rights. Do you understand your rights?
Objection. Point of clarification, sir. To my knowledge, you're violating my substantial rights at this point. I'm just trying.
You don't even know what your rights are, Mr. Gonzalez.
I don't?
You read some garbage on the internet. You think you have a better understanding of the law than everybody else in this room.
No, sir. I just realized that I'm not the surety and that you're
I'm going to
the...
ask you simple yes and no questions, sir.
Sir, point of clarification?
Do you understand your rights?
I just understand that you are the surety, you are the trustee of this
Mr.
matter.
Gonzalez, I'm going to ask you one more time to stop interrupting me. I'm going to ask you a question. It's yes or no. Do you understand your rights as I've explained them to you?
No, I do not.
Okay, which right don't you understand, sir?
Well, the fact that I have the right to face my accuser, I don't see the accuser here today.
That's because we're not set for trial today, sir. We're set for arraignment. At the arraignment, it is a hearing where you're advised of your rights, you're advised of the pending charges, you're advised of the possible penalties and the possible pleas. If you enter a not guilty plea, then we'll schedule the matter for trial, and that is the day that the state will call its witnesses, and you'll have your right to confront and cross-examine those witnesses.
Okay, do I have a right
The
not...
witnesses do not appear at arraignment, sir.
Okay, do I have a right not to be subjected to bills of attainder? Is a bill of attainder unconstitutional, sir?
I don't know what you're talking about, sir.
You don't know what a bill of
You're talking
attainder
about
is?
the bond that you've had to sign?
Well, I know what the bond is. I'm talking about the bill of attainder, the charging instrument, the original charging instrument that nobody can provide for me.
Well, sir, I think you got a copy of that on the side of the highway.
I would like to see the original with the wedding signature. It appears to me that everything has been digitized and that it has been altered.
Well, I don't know that it's been altered, sir. It's been amended by intermediation with a pen setting forth the penalties for each of the counts. But if you'd like, before your trial, I'll have Mr. McQuay's office file a formal complaint. Mr. McQuay, if you'll please hand Mr. Gonzalez a copy of the complaint that your office filed to the court.
Certainly.
It's a standard practice in every state, as well as the state of Nebraska. The uniform citations and complaints for traffic offenses are filed with the court. The uniform citation and complaint clearly sets out each of the three charges, and the county attorney has, by interlineation, amended that uniform citation and complaint to set forth the penalty in each of the charges. And you've been advised of those penalties.
So I need clarification one more time. And I thank you so graciously for working with me here because I'm fascinated by this whole procedure and process.
I'm sure you have been.
I am. So on the record, has a performance bond been established for and on the official record? Because I have not seen that. The only thing that you're stating here that is on the record is prima facie evidence of alleged indebtedness in a contract for which the affidavit has been
There's no alleged indebtedness, sir. The document sets forth the scheduled fines if you chose to pay it by waiver. The document says that you violated 3 separate laws. I've explained the penalties for your violations.
Okay, so
and
this...
now we're going to move forward, sir.
Clarification.
You have a right to receive a photocopy.
Objection.
Of the complaint. I'll note for the record that you've received that copy.
Objection, sir. I have a point of clarification.
Now be quiet. You have a right to a speedy public trial. That's within 3 to 6 months from the date the complaint was filed with the court, sir. Your complaint was filed on May 30th, 2018, which means the state has to bring the matter to trial sometime before November 30th.
Objection, sir. I've got a point of clarification here as well.
Sufficient time to prepare a defense to the charge. You also are presumed to be not guilty and have a right to require the state to prove your charge beyond a reasonable doubt. You have a right to receive a list of the state's witnesses, and you have a right to confront and cross-examine those witnesses. And after you enter your plea, sir, you can enter into a discovery agreement with the state, or the court will order the state to provide you with a list of witnesses by a date certain. You have a right to compel witnesses to attend in court, which, sir, means you can file precipices with the court, and the court will issue subpoenas to arraign people or to force people, compel them to appear in court to give testimony on your behalf. You also have a right to remain silent, sir. No one can force you to testify about the matter that brings you before the court. And you have a right to testify if you want to. Keep in mind, if you choose to testify, anything you say can be used to prove the charge against you. You have a right to a trial by jury, sir. And since none of these are class 1 misdemeanors or higher, you must request that jury trial within 10 days of entering your not guilty plea. You understand that right?
No, sir, I've got some clarification. Earlier you
Sir,
stated
that's the
something.
rules of this court. You understand that right?
you assume-
If you don't like my rules, you can appeal me to a higher court.
You assume
don't
facts
like
not in
what-
evidence, sir, and I'm just trying to have an ascension of the minds so we can move forward in an expedient manner, sir.
Sure, I can tell.
Wonderful. So, with that said, are you guys all going to put your bonds on this case so I can see
I'm not
it?
required by law to post a bond. I don't have a bond. I have immunity from the bench. So I do
Immunity
not
from the
have a
bench?
bond.
Can you explain the immunity from the bench, sir? That's something I
It's
have
in the
not
law,
found.
it's in the Constitution.
Where might I
It's
find that?
And I'm not here to teach you law school. So
Oh,
if you don't understand the law, you can either hire an attorney or you can ask for court-appointed counsel. But I'm not playing games with you.
Okay, so are you on
Sir,
your oath today, sir? Are you on your oath today?
Absolutely. I
Okay,
have
and so
been
is this
sworn
not a
in.
bill of attainder?
I have been sworn in. That's not a bill of attainder.
It's not a bill of attainder.
No,
What would you
not my
classify?
legal-
What
not
would you
my
classify it
legal-
as, sir?
Sir, I just told you, I answered your question.
Can you put it in writing for me, sir?
Sir, we're moving on. You have a right to trial by jury. You have a right to have the court set bail if you're being held in custody. Looks, I think you already signed a bond when you were here last week with Judge Meade. And you signed it under protest.
No, I said it painted the drawer for Derek Gonzalez by Derek Gonzalez. It should be technically sent to the state treasury,
You have a
correct?
right to appeal any final decision or order of this court to a higher court. You have a right to have time to talk to an attorney, sir. Do you wish to have time to talk to an attorney? Or are you going to represent yourself?
Well, let me ask you
Sir, you
this.
wish to have
For,
time to talk to an attorney, or are you going to represent
I just need
yourself?
clarification on that. Is a bar member's first allegiance to the court first and foremost as an officer of the court?
Sir, are you going to have, you wish to have time to talk to an attorney, or are you going to represent yourself?
I have counsel, if that's what you're asking.
Okay, you have with
My-
counsel. Have they entered in appearance yet, sir?
No, they have not,
Okay,
because
we'll give them time to enter appearance.
I continually get denied my counsel because they're not bar members. But from what my studies have conclusively proven, Your Honor, is that the bar members have an allegiance and alliance first and foremost as officers to the court, not to their client. So I refuse to be bamboozled by a RICO Act where everybody acts in concert against me. These special proceedings are absolutely appalling, and I'm just looking for clarification from you. Are you a ranking bar member at this moment in time, sir?
A ranking bar member?
Are you a bar member,
We're
sir?
required to belong to the bar so we can practice laws and statutes.
So you-
sir. It's in the state of Nebraska.
And you're very much well
Required
aware
in
that the
every
American
state.
Bar Association is in fact
I'm not a
a...
member of the American Bar Association.
Okay, but you're a member of the Bar Association and thus being part of a monopoly, and here your prosecuting attorney is also a bar member. You both have an allegiance to this court.
That's your opinion, sir.
No, it's fact in law. It's
Oh,
fact in
fact
law.
What law? Can you cite me to a statute?
Well,
that says
again,
that?
you said the discovery of evidence for facts in law will be at a later date, so I will gladly bring those
Okay,
to
yeah,
you.
wait.
So can I see the evidence on record of bonds and stuff established prior to our next court date? That way I can review everything and make sure that I go through it specifically with the intent of expediting this process, sir.
You can file your discovery request with the state, sir. I'm not addressing your discovery.
Okay, and earlier you said that I'm innocent of the charges until proven guilty. Am I innocent of the element of jurisdiction? And has jurisdiction been established for and on the official record at this point by sworn affidavit?
You're here, sir.
I'm here as representation for Derek S. Gonzalez.
You've identified yourself as Derek Gonzalez.
No, I've identified.
You've signed an affidavit and filed it with the court at 8:37 a.m. identifying yourself as Derek Gonzalez. And sir, you didn't note that affidavit was for limited appearance, and so as far as I'm
Limited
concerned,
appearance, thank you.
submitted yourself to the jurisdiction of the court. So you're here. You signed a bond at your last court hearing.
Can you
and
put that on
you
record for me so I can
submitted
review
yourself to
that?
I just did, sir.
Wonderful.
So, sir, there are 3 pleas available to you: not guilty, guilty, and no contest. Sir, do you wish to have time to consult with your attorney before you enter a plea?
Yes, I will take that up. I don't know that it's necessary to plead. Like I said, Derek S. Gonzalez did appear via affidavit. I understand
You're sitting right in front of me, Mr. Gonzalez.
there's a
I see you.
language discrepancy and barrier. Obviously, you wanted it to be in a limited appearance, so I'll go ahead and correct the record for you
Too late,
on that.
Sir. You've already
And,
filed this affidavit. You've already appeared. You've already been arraigned. So I have jurisdiction over you. You've signed a bond agreeing to be here. So we're going to go forward with your case. Now, do you want to enter a plea today, or do you want to come back and enter your plea with your attorney?
And my counsel. It'd be my counsel, not an attorney. Are you
You'll have
willing to
be an
accept my
attorney,
counsel?
Sir, he won't be able to sit by you.
Clarify.
The state of Nebraska requires that all attorneys be licensed to practice, and if they're not licensed to practice, it's the unauthorized practice of law, and he cannot sit next to you.
Wonderful. So clarification. Does your counsel, your prosecuting attorney, does he have a license issued by the state of Nebraska at this point in time that he can produce on and for the official record? You just stated that you must be licensed by the state of Nebraska, and
by the state to practice law, correct?
Yes, Your Honor.
you are licensed. Can I see that physical and
That is through the
pure?
Nebraska State Bar Association, correct?
Actually, through the Nebraska Supreme Court, Your Honor.
Okay.
So
You have
can
a license from the Nebraska Supreme Court.
I will need that on file? His license
You can do
issued
your
by the
request.
state of
You can
Nebraska.
make a request for discovery.
Request
Sir,
for discovery. Okay. So he will in fact produce his license issued by the state of Nebraska to practice law. Correct?
if you file a request for discovery, I'm sure he'll respond.
And do you also have a license to practice law issued by the state of
I have a
Nebraska?
license to practice law issued by the United States District Court of the state of Nebraska, issued a license to practice law from the Nebraska Supreme Court.
Wonderful. And can you make sure that's on record as well, sir?
Well, sir, those are my documents. You can certainly contact the clerk of the Supreme Court, the clerk of the United States District Court for the state of Nebraska, and ask to see my license.
So you do not have an obligation or a duty to produce those on and for the official record for my reviewing purposes?
I don't believe I do, sir.
I would like to challenge that, and I would like to see that on
That's great.
and for the record.
You
I'd like to know that
filed
you're
the
bonded and
You filed the
insured.
appropriate motions, Mr. Gonzalez, and we will certainly take them up.
You never did answer my question of whether or not I was presumed innocent of all elements, including jurisdiction.
I told you that I already have jurisdiction over you, sir.
You're
I
claiming
told
that you have
you're presumed
jurisdiction,
innocent.
but you're assuming facts that are not in evidence, sir, and I'd like to see those facts on evidence.
Don't interrupt me.
Why are you making loud
Don't
noises?
interrupt me. I will find you in contempt of court. I've about had it with you.
Objection.
Running your mouth out of order.
I'm just trying to figure things out.
No,
Objection.
you're not.
Criminal.
No, you are not.
Criminal
you
or
are
civil?
constantly interrupting me, and I've about had it.
Okay. Point of clarification. You
No,
mentioned.
I'm not recognizing you right now.
So what am I-
I'm telling you one more thing, sir. Do not interrupt me.
How are we to have an ascension of the mind,
Because
sir?
we can never have one if you keep interrupting me because you think you're right. You think you know everything, and you don't.
I don't know everything.
So
I'll be the first
I
to
want you
admit
to be
that.
quiet, and I want you to just listen and
Can-
answer my question.
Can I ask a question here? You said
No, you
contempt,
cannot.
and
I'm
I was
not
asking.
recognizing you right now. You do not have the floor, and it's not your turn to talk. It's my turn to talk.
How are we supposed
Shut
to?
your mouth.
Okay, go ahead. Proceed.
I'm going to. Sir, are you going to come back with a licensed attorney to enter your plea, or do you want to enter your plea today?
I don't know that anybody's licensed. I'll ask him if he's licensed, so I'll have to. We'll have to wait until I can confirm that he's licensed by the state of Nebraska. Because to my knowledge, nobody is licensed
So
by the
you're
state of
requesting
Nebraska.
for a continuance to be, to have time to consult with your counsel or an attorney?
Yeah, it'd be
And
a
we'll
2 week
come back for
leeway.
entry of a plea then at a later date and time.
I do have some questions for him on the official record. You mentioned contempt earlier. Would that be civil or criminal?
I don't care.
I would request 2 weeks. I've got some things that I need to handle and some affairs that need to be taken care of.
Okay, we're coming back August 2nd, 2018 at 1:30 for entry of a plea. You promise to be here at that date and time, sir?
Always. Can you give me another bond and make it 10,000 this time? I'd love that.
No, sir, I'm going to release you on the bond you previously posted.
Can we
And-
increase it by chance?
No, sir, it's significant, it's adequate, you appeared on it.
I don't know that it'll cover all my travel expenses and stuff, so I would like to make sure that it incurs and covers all
Sir,
travel and study.
I don't think you understand what the bond is for. So today I'm going to release you on the bond previously posted and your promise to appear
Do I have-
1:30 August 2nd,
Excuse me,
2018.
point of clarification?
We're adjourned on your case.
I'd like to ask about
Adjourned on your case.
subrogation, sir.
We're adjourned on your case.
Okay, well, it's very clear. All right. So am I free to go at this point? Am I free to go?
You are free to go.
All right.
You're released on the bond you previously.
Will it be another judge that?
You promised to be here. I'm afraid I'll be here, sir.
Oh, wonderful. That's fantastic. All right. Thank you. All right. See you later, partner.